Did you mean this or say this? Okay, so we are now live streaming to my YouTube channel, and this is the court's ruling on the plaintiff's motion in limine, which I've just heard argument on. And as I was starting to explain, it's a little bit difficult to rule on some of these evidentiary issues for several reasons. One, sometimes it's just not clear what exactly the opponent of the evidence or what exactly the proponent of the evidence is going to use it for. And so the opponent of the evidence is trying to make an argument that it can't be used for a particular purpose, and that's not the intended purpose of the proponent. And those things are hard to know in advance of trial. And some of these things are better ruled on when the court can actually hear the evidence. A motion in limine is helpful for a couple of reasons. One is if there's something that just by asking the question, it would prejudice the case. If the evidence is inadmissible, then when it's so prejudicial that like you can't unring the bell, it is helpful to have a motion in limine. But most of these issues are not really like that. I appreciate that attorneys want to know what's going to come in and what won't come in ahead of trial because it helps you prepare. But it's not always possible because, again, it's not always clear how the proponent of the evidence is going to use it. And evidence could be inadmissible for one purpose, but it can be admissible for another purpose. So with all of those disclaimers, I'm going to address the issues that are raised by the defendant. First of all, the plaintiff, pardon me. The plaintiff wants to preclude the Hughes defendants from calling Jeff Hicks, who is in-house counsel at DART. And of course, the objection to that is attorney-client privilege. However, the defendant, and by defendant I mean Hughes defendants, the defendant lists on page 5 of their response a number of details about these transactions that presumably Mr. Hicks would have knowledge of and presumably would not invade the attorney-client privilege. And presumably could be relevant to the things that are at issue here. So it's really impossible for the court to know exactly what Mr. Hicks' proposed testimony would be. And I don't think it's necessary that I rule that attorney-client privilege would completely rule out his testimony, because of course it would not completely rule out his testimony. And there are details of the transactions that could become relevant that Mr. Hicks could testify to. And so that's one of those areas where, to the extent that he's asked about anything that infringes on attorney-client privilege, an objection can be made. But I'm really confident that the defendant understands the scope and the importance of attorney-client privilege and is not going to go there. But if there's a dispute about it, it could be settled at trial with an objection and a ruling by the court. But at least the defendant has demonstrated that there is theoretically some non-attorney-client privileged information that Mr. Hicks would be able to testify to. So I am, I guess, saying they're not precluded from calling Mr. Hicks, and I'm reserving any ruling on his testimony until we actually hear what the proposed elicited testimony would be. With regard to the next topic, which is the plaintiff wants to preclude any evidence of a custom or practice of paying referral fees, I am ruling that actually under the statute, which is 750.125, and this is subparagraph 4, that evidence is not necessarily precluded. I'm looking at the precise language of the statute, and it says that evidence isn't admissible to show that a gift or acceptance of a commission or money or property or other valuable thing, quote, described in this section, end quote, is customary in a business, is not admissible. Well, described in this section are not legitimate commissions or gifts or things that are paid, but are illegitimate and illegal gifts and commissions and things that are paid. So I do not think the defendant is precluded from introducing evidence that commissions are paid. The idea, I think, behind the statute is that you can't say, well, it's not illegal, because even though it might be illegal, everybody does this illegal thing. And that's the intent behind it. So if the defendant wants to introduce evidence of the fact that legitimate commissions are paid on these types of transactions, then I think they can certainly do that. I understand that the plaintiff maintains that everything that's at issue in this case paid as a commission is not legitimate, but the defendant is entitled to a defense, and their defense is that it is, and that it's no different than other legitimate commissions that are paid. So I will not preclude that testimony. The next topic is the fairness of the transactions and the quality of Hughes' work. These are two areas that, again, are so broad and so inclusive of so many possibilities in the way of evidence that I think it would be wrong for the court to rule across the board that this can't come in, because it would create all kinds of questions about, well, how far are we going? If we can't talk about the fairness of the transactions, can we talk about the details of the transactions? If we can't talk about the quality of Mr. Hughes's work, can we talk about the nature of Mr. Hughes's work or the details of Mr. Hughes's work? I don't want to create those issues. I think we can deal with these things with objections at trial. But I will say this. If the purpose, and this is what I gleaned from the response, if the purpose of showing that Mr. Hughes's work was of high quality is to show that he had no reason to influence decision-making by giving a personal benefit to Mills, then that's a purpose that I would reject. Now, there can be other purposes for offering evidence, but that's a purpose I would reject, because that's the same as saying that Mr. Hughes had no motive to do this. And motive is not an issue in this case. That's different than intent or knowledge. Those may indeed be an issue, but to show that, oh, his work was so good that he had no motive to do this is not relevant to anything that's an issue in this case. As far as the fairness of the transactions, the defendant, in my reading of it, mischaracterizes the plaintiff's claim for damages and then tries to justify the evidence based on that. But the plaintiff isn't claiming that it would not have engaged in these transactions. And I think we finally settled that and cleared that up a while back. The plaintiff is claiming that it overpaid commissions to Mr. Hughes because it was actually paying for inflated commissions without knowledge that part of that was going to allegedly unlawful payments to Mr. Mills. So you can't say that that the fairness of the transactions is relevant to show that the plaintiff would have engaged in these transactions anyway. So, to that extent, that's not a permissible purpose. But again, I'm hesitant to say across the board, you can't bring in fairness of the transactions, because where would that end? How would we draw that distinction in advance? Would it mean you couldn't bring any of the details in? I don't think it means that. So that's something that we can deal with on an as-needed basis through actual proposed evidence and objections as needed. The next category is the plaintiff wants to preclude any evidence of Mills' alleged representation that he was allowed to receive payments from Mr. Hughes. But again, evidence that's inadmissible for one purpose may be admissible for another. So Mr. Mills' statement cannot be attributable to DART in the sense it can't be used to show that DART authorized the payments. I've already ruled on that. That's a matter of agency law that I've ruled on. But Mr. Mills' alleged representations could be used to show intent or knowledge or lack thereof by Mr. Hughes, and I won't preclude the evidence for that purpose. Now, of course, if there's any suggestion or any argument that the statement of authorization, if you want to call it that, is attributable to DART under some kind of agency, then I will appropriately instruct the jury on the proper use of that evidence. But as long as it's for improper use, I will not preclude that evidence. And then the next category is not opposed. I think everyone is in agreement that the traceability of the payments to a particular transaction is not necessary. And the court has already ruled on Mr. Hughes' status as a matter of law as a fiduciary. I understand the defendant's statement that they're not conceding anything in that regard. And then the last category is about the size and structure of DART container. And the defendant justifies this on two grounds. First, the defendant says it's relevant to whether Mr. Hughes intended to improperly influence Mr. Mills' decision-making regarding DART's business, and then it's relevant to Mr. Hughes' intent in making the payments. But again, I think that's a bit of a mischaracterization of what has to be proved by the plaintiff, because nothing in the statute, the anti-kickback statute, says that the payment has to actually influence the plaintiff's business. Certainly nothing has to be shown that there was any influence on the plaintiff's business globally. There only has to be an agreement or an understanding that Mr. Mills and between Mr. Mills and Mr. Hughes, that Mr. Mills would act in a particular manner in relation to the plaintiff's business. But that doesn't mean globally they have to show that it actually affected the plaintiff's business. There is the damages element, but even the damages element looks only at these particular transactions and the commissions from them to measure damages. And it doesn't look to any overall impact on all of DART Container's business. So you can't justify it in that sense. And it's really nothing more. To get into the whole size and structure of DART Container is nothing more than an invitation to the jury to dismiss any alleged damages as just, a drop in the bucket to a corporation that is very huge and prosperous. So unless there's some particular evidence about size and structure of DART that is relevant to something that is at issue in this case, and so far what the defendant has put in their response, I reject for the reasons that I just gave. But unless there's something in particular that is relevant and doesn't go to the profitability of DART Container overall in order to tempt the jury to dismiss the damages as inconsequential, then I am going to preclude that evidence. And that addresses all the topics that the plaintiff raised in the plaintiff's motion.
Your Honor, may I ask one question just for the record so we clarify it?
Yes.
The one issue that was part of the very last thing the court addressed was specifically the wealth of Robert Dart and Kenneth Dart, and Ms. Gross agreed in her argument that that was improper. Just so we can, when we prepare the order, can we squarely indicate that that is granted, at least that part of it?
Yeah, let me review it again. Did you quote, I don't remember, did you quote a specific?
Yeah, our last argument, Your Honor, we specifically did mention the individual wealth of Kenneth and Robert Dart.
Yeah, the individual wealth, I cannot see any possibility of that being relevant.
Thank you, Your Honor.
Thank you. And then if there's no other questions, that will conclude our hearing. And Mr. Mandel, do you want to do an order that attempts to reflect that?
We will do that and we'll share that with Ms. Gross, Your Honor.